This is where courtroom sympathy collides with courtroom reality. Self-defense, second chances, and a judge who's clearly run out of patience.
I mean, we're talking about a misdemeanor assault between children, not a.
Well, I don't know that. I mean, you're
Well,
putting in stuff that I have no
the
idea
state
about.
alleged a misdemeanor assault. They didn't allege an aggravated assault, which they could have, and they did not. They alleged a misdemeanor
Doesn't make
assault.
me feel better.
Well, I mean, the state says, alleges that there's all this injury. We can see what the injuries were. You see the plaintiff witness in a picture. She's smiling.
Did you go to
she's
the
talking
hospital?
to the police. No, she didn't go to the hospital, Judge.
I don't know.
I've read everything. She hasn't gone to the hospital. She has a swollen eye, is what she has.
Judge, I don't believe, I mean, her hair was also ripped out, Judge, based on what we see in the four corners of the dims. We haven't done.
I don't know. I mean, there's a lot of people who wear different types of hair.
Sure.
So,
But just going off the dims, we have her hair being ripped out and being stopped. So,
And to your question, not hospitalized, Judge.
so here's what I'll do.
Judge, just if I may add, even in the first AFM, Judge, the complainant has gone back to the home at least once, to my knowledge, based on my communications with the complainants on that case. The defendant has gone back to the grandmother's homes, contrary to the bond conditions and the no contact orders in that case. He's repeatedly, time and time again, violated his bond conditions, and now so we would be opposed to anything less than $1,000.
Yeah, I know. So what I was going to, his bond on the first assault it's $1,500. I'll do 2501 on that. Okay, I'll only raise it at $1,000. On the new case, what do you think? Should we give him a PR bond?
Judge,
No, Judge.
we'd be opposed based on the nature of the allegations where he stomped on someone's head, pulled her hair, and in addition to that being picked up just a month after the previous AFM.
And charged with a misdemeanor. I mean, if the state felt so vigorously about this case, then they would have filed it in district court. I mean, this is a misdemeanor assault between.
I think there's no way this would have been gone upstairs.
I agree, and which is why I think a personal bond could be adequate in light of the fact that he would be given a surety bond on his previous case. He doesn't have much of anything. If anything, that keeps him in jail until we get to trial, because that would be a case that we would set.
All right, Mr. Brooker, I'll set the new one. I'll set it at $500.
Thank you, Judge.
I hope you get it. You're going in today, but I hope you get it. I mean, we're not going to stand for this. You got to pay the piper. And I don't know if it's dealing with the school now will get you to wake up and realize that you can't do what you're doing, but that's it. I've literally bent over backwards not to put you in jail, Mr. Smith. Literally bent over backwards. How many chances have we, Yeah, goes with you. Okay, Mr. Smith, good luck. Ma'am, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer was driving on Katy Freeway in Harris County, Texas, when he observed the defendant's vehicle driving at a high rate of speed, rapidly accelerating, making evasive lane changes and aggressive maneuvers without signaling, cutting off multiple vehicles, and making those drivers take evasive action to avoid a collision. While the officer was attempting to catch up to the defendant, he reached speeds in excess of 120 miles per hour. The officer then conducted a traffic stop, and the defendant stated she was driving that way because she was late to work.
And I'm going to find that there's probable cause to go forward with your case. Do you see if she has a valid Texas driver's license? Okay. If I find that you drive like this again, because I'm making a bond condition that you're not to drive like this, if I find that you do, I will take your privilege to drive away from you while this case is open. Do you understand? Living in a city as big as Houston without the ability to drive is absolutely awful. Don't. I'm going to protect my city at all costs, and if I have to put you in jail because of it, I'm going to have you sign. How old are you, ma'am? Okay, we're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign and reset. After that, I'll have you take your seat in the jury box. I'll get your bond conditions, no racing, reckless driving, anything of this nature. After that, I'll have you sign it, and then you'll be free to go. All right. Good morning, Mr. Harvey. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer was parked and observed a road rage incident occur. The officer observed the defendant's vehicle laying on his horn and speeding up to cut off another vehicle. The officer observed the defendant slamming on his brakes, and the driver of the other vehicle then attempted to drive around the defendant when the defendant cut her off again and slammed on his brakes, nearly causing her to drive into a ditch and nearly causing an accident with other vehicles.
Important legal line here. Self-defense doesn't extend past the threat. Once someone is on the ground, stomping turns defense into a brand new crime.
The officer then initiated a traffic stop and pulled into a nearby parking lot.
Mr. Harvey, I'm going to find that there's probable cause to go forward with your case. Patience. Patience when driving. And I'm going to have you sign a document promising me that you're going to exercise this patience and not drive in this manner again. And if I find that you do, I'm going to put you in jail. Do you understand? How many times do we have people on the road that sit there and get shot because of the incidents like, don't drive recklessly. Those conditions like we did in the other case.
Yes, Judge. Yes, Judge.
Harvey, we were going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. We'll then have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. Wait, does he have a Texas? Can you run his license, please?
Expired. I see eligible on RN. I can run it again.
Please. If you do not have a Texas driver license, then do not drive. I will have you sign an affidavit today with me promising me you're not going to drive unless you have a valid Texas driver license and liability insurance. It is your responsibility to reach out to DPS to figure it out. Do you understand?
Yes, I see eligible on our end.
Okay, I'm going to have him sign it. And then if you do, if you have a license and liability insurance, you can drive. If you don't, then don't. If I catch you doing it, it's not going to go well for you. You understand? Okay. You were charged with driving while intoxicated, second offense. The reason that we are taking you into custody now is that it looks like you're on probation for a felony retaliation case, which is now set at no bond. So we're going to do probable cause here today. If there is enough.
I'm sorry, I can't hear.
You're on felony probation. Looks like a warrant has been issued in that case. Bond is set at 0. So we'll do probable cause here. If I find probable cause, well, either way, we're going to, provide your lawyer today. But for now, we'll do probable cause on your DWI second. You're facing up to a year in jail and or a $4,000 fine.
Yes, Judge. The officer initiated a traffic stop in Harris County, Texas, after observing the defendant failed to yield to a right-of-way in an intersection and for driving with an expired registration. Upon contact, the officer observed a moderate odor of an alcoholic beverage and slurred speech. The defendant admitted drinking 2 beers and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 5 out of 8, and the defendant refused to do the one-leg stand. The DIC was read and breath was consented to. The results were 0.139 and 0.146.
All right. Have you seen whether she has a valid Texas driver?
It's not eligible, Your Honor.
All right. Ms. Gutierrez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive. It is a condition of your bond, and you will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Now, I don't know if you're going to get out of custody, but if you do, you will be required to obtain a handheld interlock device that you're going to take with you to prove to me that you're not consuming alcohol. We will also be sending word to DPS so that every officer in this state knows if you're in a vehicle driving, you will be required to have an interlock in that car. So if they catch you driving hard that doesn't have an interlock on it, you're going to be going right back to jail. You understand?
Okay.
No alcohol, no drugs, and I'm going to randomly test you as well. We will provide you a lawyer today so that you can talk with this person to figure out how we go forward with the case. All right, come on, we'll have you sign this and then we'll have you sign your conditions, ma'am. Mr. Martinez, you're charged with racing on a highway. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 27, 2024, the officer was assigned to a traffic crimes task force and followed a group of 40 to 50 racers from 2400 block of Turning Basin to the 610 loop. The officer
Say 40 to 50 racers?
Yes, Judge. And the officer observed the defendant and co-defendant's motor vehicles in lane 1 and 2 slow down to approximately 30 miles per hour, and both vehicles took off side by side, trying to outpace each other at approximately 100 miles per hour. A traffic stop was conducted, and the officer made contact with the driver, the defendant, and he was the sole occupant of the vehicle.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has a valid?
He's not eligible, Your Honor.
You are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive, and I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing every time you drive. It's an offense in and of itself, punishable by up to 6 months of jail and a $500 fine. Do you understand? Do not drive.
Now the tone shifts hard. This isn't about punches anymore. It's about a high school senior, graduation on the line, and a future that could disappear overnight. Honest question, should a judge bend when college, graduation, and homelessness are involved? Or does public safety outweigh potential futures every time?
Whenever you fill out the affidavit promising us you're not going to drive, we will get you to Victoria, sign a reset, and we're going to get you out of here. When you come back, please have a lawyer. Sir, you were charged with unlawful carrying of a weapon, and you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 27, 2024, the officer observed the defendant's vehicle failed to maintain a single lane and veering over the left lane on 3 separate occasions. A traffic stop wasn't conducted, and the officer made contact with the defendant, the driver of the vehicle. The defendant advised he was unlicensed and that the motor vehicle was not insured. The officer observed a strong odor of marijuana emitting from the passenger area of the vehicle, and the defendant voluntarily produced a partially burnt marijuana cigarette and stated it was the possible source of the smell. The officer conducted a search of the defendant's identifying information, which yielded an open felony warrant for continuous violence, and a search of the defendant's left jean pocket yielded a clear plastic baggie containing a green leafy substance. The substance was identified as marijuana based on training experience. The defendant's motor vehicle was searched incident to arrest and yielded an unholstered AR-15 pistol on the front.
AR-15?
AR-15 pistol, Your Honor. And the defendant acknowledged ownership of the firearm and stated he used it for protection since his brother is a famous rapper.
Find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I'm going to put you in jail. Do you understand? You do not have a Texas driver license. You are not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in this life. I don't care where you got to go. I don't care what you got to do. If you don't have a license and liability insurance, do not drive. Do you understand? How old are you, sir? What do you do for a living? Why?
I don't work.
How do you support yourself? How do you support yourself?
My brother supporting me out. I ain't go out looking for a job yet.
It's time. I will provide you a lawyer today, but it's time to get a job, a full-time job. When you have too much time on your hands, you become self-destructive. Not here. Do you understand?
Sir.
All right. Do you mind giving an application, please? I need you to fill out an application for me. I'm going to have you sign a receipt, Victoria. I'm going to have you meet with Felicia for your bond conditions, and then we're going to go. I'm going to get you on the right track, Mr. Galden. Come on. Good morning, ma'am. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The complainant and the defendant are in a dating relationship as of 6 years. And on December 28th, 2024, the officer is dispatched to a disturbance at a residence in Harris County, Texas. The officer met with the complainant, who stated he was assaulted by the defendant at around midnight that morning. The complainant stated he and the defendant had been at a comedy club and the defendant was drinking. An argument ensued and the complainant began gathering his belongings, and the defendant punched the complainant in the face with her left arm, making contact with the center of his face. The complainant said the defendant also slapped him with an open fist on his right cheek twice, causing pain.
Got it. All right, ma'am, I'm going to find that there's probable cause to go forward with the case. Do we know whether he wants to have contact or not? You guys reached out to him?
Work was attempted this morning, but unsuccessful.
Okay, because I don't know what this person wants. I'm ordering you not to have
We have
contact.
a contact or no contact.
Stop. Don't say anything. I'm just telling you what the expectation is, so you know, because if you violate these conditions or if you pick up a new case, I'm going to revoke the bond. We'll put you in jail. No more PR bonds. So no contact, no weapons. There is a protective order.
This is the line in the sand. Repeated bond violations flip the switch from mercy to consequences, and the judge makes it crystal clear why. One case ends with jail, but the docket doesn't slow down. What follows is a parade of reckless driving, DWI, and courtroom warnings that sound polite until they aren't.
That has been issued in this case, get to know it, because if you violate the protective order, they can file additional charges against you. Do you understand? So what we're going to do now is I'm just going to be sign a reset with Victoria. We'll have you take a seat in the jury or wait for your lawyer to get here.
He's not gonna come. They've already contacted you guys and let you know he's out of town and he'll be back on the 9th. They said I just needed to come and sign my bond conditions.
Okay.
It's Maverick Ray.
Contact and no weapons.
Yes, Judge.
All right. So what we'll have you do is we'll have you just take a seat. We'll have you sign a reset. And I don't know, perhaps did you hear from Maverick at all?
No. They did try to reset it, but I said there would be bond conditions for her.
Did they give you a good date?
He's back on the 9th.
2 months out, and if it didn't work for them, they could.
Got it. Okay. So we'll have you sign a reset and we'll just have you take a seat in the jury box. Please. Hey, how are you? Mr. Stewart, what's new?
Sir, how was your New Year?
Great. We did PC on your case.
Okay.
We just did stand up. What's your guy's name again?
My last name is Allen, Your Honor. I would like to make an argument on PC. I don't know whether.
Absolutely. I'm always ready to hear it. So refresh my memory. What happened?
So in Allen's case, it was where the officer came to a stop behind the defendant's vehicle and the light turned green. The
But he had
defendant,
expired registration, right?
no, Your Honor. In this case, the defendant's vehicle proceeded through the green light and immediately drifted approximately halfway onto the shoulder with other vehicles around it and then jerked back into the lane.
Were there any other vehicles around when this happened?
Yes, the officer explicitly wrote there are other vehicles around the vehicle before the driver jerked back in the lane. So he went into the shoulder and there are other vehicles.
Go ahead.
Yes, sir. My argument is, Your Honor, that, as far as what's actually alleged, says the light turned green and the truck along with several other vehicles proceeded, which obviously is in compliance with the law. The only argument that the state has made here elucidated is that they observed a Silverado drift into the shoulder with other vehicles around it. If he's drifting into the shoulder, that's not endangering any other vehicle. That's not an allegation of the safety of anybody else out there on the roadway. The shoulder is away from any other vehicles. Maybe he's doing this in an abundance of caution. There's no indication that it was dangerous or endangered any other vehicle, anything like that within the allegations here. Furthermore, there's numerous reasons why a vehicle is 100% legally allowed to drive in the right-hand shoulder of a vehicle. I think there's 9 reasons in the state of Texas why a vehicle is allowed to drive in the shoulder. There's nothing here that alleges that basically he committed any sort of crime that would lead the officer to then stop him. This is insufficient information, and I would argue that there's not valid probable cause here on this case.
I think he has a valid point where, perhaps he's Well, I mean, I don't want to speculate, like, and you're saying, well, maybe he did it because of this, that, but I don't want to speculate, right? Because were there other cars? I don't know. Was it dangerous? I don't know. I mean,
Judge, but failure to maintain a single lane when there are other vehicles within the vicinity is a valid reason for a stop.
right, but you got to articulate facts as well, right? So according to the statute,
Right, and I understand, because we've had this issue before where it's failure to maintain a single lane, but we're unsure if there's other vehicles. That I can appreciate and understand. But in this case, the officer did specify that there were other vehicles in the vicinity. And under Texas law, that is sufficient for a stop.
I disagree. I think that when we look at the statute for trying to maintain a single lane, the second half of the statute is that it endangered somebody. And there's no indication here that there was any danger.
was it 545.460? Isn't that it?
Lemming, yeah, Lemming Harden.
545.060, Your Honor. Section A2, may not move from the lane unless that movement can be made safely. Shall drive as nearly as practical entirely within a single lane, and 2, may not move from the lane unless that movement can be made safely. There's no allegation here that the movement was made unsafely. Or that there was
Judge,
anything
I
unsafe
also
about it.
have the list of, where under Texas law, where it's permissible to drive on the shoulder, to stop, stand, or park, to accelerate before entering the main lane of traffic, to decelerate.
Let's do this. I mean, this is going to take quite a bit of more time. So can you come back? Do you have anywhere else to go?
Oh, yeah.
Let me go through the arraignments, get everybody done and out of here, and then because this is going to take quite a bit more time,
Yes, sir.
right? And then give you time to take a look more. So if you need to, you too as well, if you want to try to find a case law, let me just go through because I have another lawyer that's waiting,
Absolutely.
Yeah, I'll help you out, but let me get through everything. Yeah, for sure. Good morning. Great to see you. How are you? Always a pleasure. All right. Mr. Barajas, you are charged with 2 counts of assault of a family member. You're facing up to a year in jail and or a $4,000 fine on each. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you have the right to have an attorney present, if you cannot afford one will be appointed to you, sir.
It's my understanding that the state's going to